Welcome to Telugu One Academy. In today's class, we would be discussing other functions of the President of India. So mainly we have executive functions, legislative functions, financial functions, judicial functions, military functions, emergency functions, and few discretionary powers also of the President. We'll continue in this class with financial powers of the President. So, important financial powers of the President of India. We know that money bill is an important bill to be introduced only in the Lok Sabha, and money bill is also introduced by the prior permission of the President. So, money bill under Article 110, what are the important provisions what we have under Article 110, which is money bill. So the money bill consists of the imposition of taxes or reduction of the taxes, enhancement of the taxes, alteration of the tax structure. So these are the important things which needs the President's assent or prior permission of the President before it is introduced in the Lok Sabha. Again, the money bill is introduced only in the Lok Sabha but not in the Rajya Sabha. We also have other types of bills. We also have financial bills. Financial bills are mentioned under Article 117. We have financial bills also, which are of two types generally, but whatever the things are concerned with the imposition of taxes or alteration of taxes comes under money bill. So money bill also have other provisions. Money bill under Article 110 consists of 6 provisions. So other provisions are like with respect to the Consolidated Fund of India. Whatever monies are generated by the Union government should also be put into the Consolidated Fund of India, and the custody of the Consolidated Fund of India is also with the hands of the President, within the hands of the President. We have Consolidated Fund of India, and we also have Contingency Fund of India. Under Article 266, we have Consolidated Fund of India, and 267, this is Contingency Fund of India. So Contingency Fund of India is an emergency fund for the reasons of unforeseen nature. సో మనకి ఒక ఎమర్జెన్సీ రీజన్స్ వచ్చినప్పుడు ఏదైనా ఒక ఆపత్కాలిక పరిస్థితిలో ప్రెసిడెంట్ దగ్గర కంటింజెన్సీ ఫండ్ ఆఫ్ ఇండియా అనేది ఉంటుంది. సో ప్రెసిడెంట్ క్యాన్ ఇష్యూ ఆర్ క్యాన్ స్పెండ్ మనీ from Contingency Fund of India. So that is where when the house are not in session, parliament అనేది సెషన్లో లేని పరిస్థితిలో మనకి ఏదైనా ఎమర్జెన్సీ కండిషన్స్ కానీ అరైజ్ అవుతే ప్రెసిడెంట్ ఆఫ్ ఇండియా ఈ కంటింజెన్సీ ఫండ్లో ఉన్న ఫండ్స్ని యూజ్ చేయొచ్చు. దాని తర్వాత మళ్ళీ పార్లమెంట్ సెషన్ అయినప్పుడు దాని మీద డిస్కషన్ అవుతుంది, ఆ ఫండ్ని మళ్ళీ బ్యాక్ తీసుకురావడం జరుగుతుంది. సో ప్రెసిడెంట్ దగ్గర ఈ ఫినాన్షియల్ పవర్స్ గురించి వస్తే చాలా ఎక్స్టెన్సివ్ పవర్స్ ఉంటాయి. ఏ బిల్ అయినా ఇఫ్ ఇట్ ఈస్ రిలేటెడ్ టు మనీ బిల్, దెన్ ద ప్రెసిడెంట్ ఆఫ్ ఇండియా షుడ్ గివ్ హిస్ ప్రయర్ పర్మిషన్. So the money bill also contains enhancement or reduction of the taxes and various things like expenditure from the Consolidated Fund of India or maintenance, that is custody of both Contingency Fund of India and Consolidated Fund of India. All these bills have to be introduced with the permission of the President, and President will generally give his assent to money bills because the money bills because they have introduced by the permission of the President, and if those bills are passed both in Lok Sabha and then in Rajya Sabha, then generally President will give his assent to the money bills. So money bills also contains few provisions like abolishment of taxes. That is one financial power. Again, we know that union budget is very important part in the financial powers. That is annual financial statement. We call union budget as annual financial statement under Article 112. This budget is also introduced by the President. So President has the authority over the budget. He would lay down the budget in both the houses of the parliament. So annual financial statement, which has both revenue and expenditure part of the government, it talks about the entire financial position of the country, that is both fiscal policy and monetary policy. So budget will discuss which is a lifeline of any democracy, has given president powers to decide on presentation of the budget. As we understood, contingency fund is an emergency fund which is under the disposal of President of India. So demand for grants, whatever we have a demand for grant should also be have a permission of President of India. Whatever the money raised and whatever the money is in Consolidated Fund of India or public accounts of India should be within the control of the President. So we say that President has a custody over all those monies, expenditure and revenue out and in, that is with respect to Consolidated Fund of India, Contingency Fund of India and also public account of India. The president would also have deliberations over what is the limit of the government to raise the loans. So these are all the provisions which we have in money bills. So we are just discussing about the financial powers of the president. We are not going in detail regarding money bills because it would we will discuss that in the powers of the parliament. Judicial power. So as we know, President of India is the head of the state, head of the nation, and he is also given the power, or the President of India should look after the protection of the constitution. So judicial powers is also within the hands of the President of India. President of India has enormous judicial powers, right from appointment of Chief Justice of India, various judges of the Supreme Court, Chief Justice of High Court and other judges of the High Court are appointed by the President. We know that President do not act on his own, but whatever the judges are appointed would be under the authority of the President. And we also have an important power of the President, that is President could seek advice from the Supreme Court on various legal matters concerning the nation or the government. So Article 143 talks about the advices can be taken by the President on various issues. Whatever the advices given by the Supreme Court is not binding on the President of India. So President of India, at times when there arises a question regarding legality of any policy or other provisions also regarding functioning of the democracy, parliament, or the questions on the constitution itself, the President would seek advice, that is expert advice on legal matters from the Supreme Court, and Supreme Court has to give advice to the President which is not binding, that is the whatever recommendations made by the Supreme Court regarding such matter are not binding on the President to be implemented. So enormous judicial powers. We also say that the President of India has other powers also, like Article 72. When we say Article 72, Article 72 in the Constitution empowers the President to grant pardon. We have other things like we have commutation, remission, reprieve, respite, substitution. So all these things are given by the Constitution itself. The judicial powers are given by the Constitution to the President. So when we say the President would grant pardon, here when we say pardon, it is like completely absolving the person from whatever charges or whatever convictions he has on him. So it is a complete absolving all the charges, setting free of all those convictions. So క్షమాభిక్ష పెట్టడము, ఇక్కడ పార్డనింగ్ అంటే పూర్తిగా ఏదైతే అభియోగాలు ఉంటాయో అలాంటి పర్సన్ మీద వాటి నుంచి పూర్తిగా తొలగించడము, అతన్ని ఫ్రీగా సెట్ చేయడం. సో ప్రెసిడెంట్ వుడ్ గ్రాంట్ పార్డన్ ఆన్ ద డెత్ సెంటెన్స్ ఆల్సో. which is the highest punishment. Generally, when we compare the presidential pardoning power with that of governor do not have pardoning power with regard to death sentence. But here president have the power to grant pardon for death sentence also, because as we know there may be judicial mistakes also, but president is the highest authority and he is the custodian of the constitution also. Protection of the life of the people should also be within the hands of the president. As we know, president is the first citizen of India, and whatever the issues regarding the citizen of the country should be resolved by the president. Here when we say granting pardon, there may be a chance that the court also at some times take a different view or may make mistake in giving judgments. So when the case comes to the president regarding the pardon, the president would generally take a different view on some evidences which are recent in nature, or there may be a new evidence which may be come in the picture, and based on those evidences the president can take a different view which is unlike the view taken by the Supreme Court. సో కొన్ని పరిస్థితిలో ఈవెన్ సుప్రీం కోర్ట్ కూడా కొన్ని మిస్టేక్స్ చేసే పరిస్థితులు ఉంటాయి. అలాంటప్పుడు కొన్ని కొత్త ఆధారాలు కూడా వెలుగులోకి వచ్చే పరిస్థితిలో ప్రెసిడెంట్ వాటి మీద ఒక డీటెయిల్డ్ స్టడీ చేసి ఒక భిన్నమైన ఒక యాంగిల్తో ఒక వేరే ఎవిడెన్స్తో కొత్తగా ఒక జడ్జ్మెంట్ని తీసుకురావచ్చు. సో ఇక్కడ ఏంటంటే సుప్రీం కోర్ట్ కొన్ని సందర్భాల్లో ఒకవేళ మిస్టేక్స్ జరిగితే వీ హ్యావ్ అ ఛాన్స్, దెర్ ఈస్ అ పాసిబిలిటీ దాట్ ద ప్రెసిడెంట్ వుడ్ టేక్ అ డిఫరెంట్ వ్యూ అండ్ could grant pardon to the person who got convicted by the Supreme Court. So when we say pardoning power, the person cannot go directly to the president ki direct ga person approach aye paristhiti undadu. Again there is a process, malli council of ministers recommendation meedane ivanni cheyali. The president will not act on his own. So on the recommendation of the council of ministers, the president would generally grant pardon. Deentlo kuda we have many provisions like are this power of the president, that is judicial powers of the president, are subjected to judicial review. Malli judicial review avutunda aa powers mida okasari president konni judicial powers use చేసుకున్న తర్వాత కూడా అవి judicial review ki subject avutunda. So we have many Supreme Court judgments or orders where the court has said that obviously when the decision of the president is politically motivated or if it is against a section of the society, then the president's decision is also partially subjected to judicial review. So చాలా కేసెస్లో మనకి సుప్రీం కోర్ట్ ఇలాంటి జడ్జ్మెంట్ చెప్పడం జరిగింది. సో ఇక్కడ when we say pardon, it's a setting free of all the convicts. Commutation అనేది ఇంకో పవర్ the president has. Here commutation is where the nature of the nature of the sentence is changed but the time is not changed. So ikkada we are substituting the sentence of one with another form. So in commutation, generally if the punishment given by the court, like for example if the punishment is death sentence, though that sentence is changed by the power of commutation by the president. So death sentence nunchi oka 9 years rigorous imprisonment laga ala manamu aa character ni marchukovachu commutation lo. So shiksha marpu cheyadam anedi commutation. This remission is slightly different to the commutation. In commutation, as we have said, the nature of the punishment is changed, but in remission the nature of the punishment remains but the time will change. That is the time, for example when we say 9 years rigorous imprisonment given by the any judge. ఒక పై స్థాయి ఒక కోర్టు ఒక 9 సంవత్సరాల కఠిన కారాగార శిక్ష అనేది ఒక జడ్జ్మెంట్ ఇస్తే రిమిషన్ పవర్ యూజ్ చేసి ప్రెసిడెంట్ దాని యొక్క సెంటెన్స్ని తగ్గించవచ్చు, అంటే టైంని తగ్గించవచ్చు. 9 years నుంచి 5 years తీసుకురావచ్చు. సో శిక్షని ఇక్కడ తగ్గించడము, సమయాన్ని తగ్గించడము. సో వెన్ వి సే కమ్యూటేషన్, in commutation the nature of the punishment changes but not the time. In remission the nature of the punishment do not change but the time can be decreased. So that is a remission. Reprieve is just putting a stay, that is temporarily postponement of the అవార్డ్ ఆర్ ద పనిష్మెంట్. సో రిప్రైవ్లో మనకు ఒక తాత్కాలికంగా ఒక రిలీఫ్ ఇవ్వడం జరుగుతుంది. సో ఒక పోస్ట్పోన్మెంట్, ఇప్పుడు కాకుండా మళ్ళీ కొంత సమయం తీసుకున్న తర్వాత దాన్ని అమలులో తీసుకురావడం జరుగుతుంది. అది ప్రెసిడెంట్ దగ్గర ఉన్న పవర్, జ్యుడిషియల్ పవర్స్లో. రిప్రైవ్లో ఏముంటుందంటే శిక్ష అమలు కాకుండా వాయిదా పెట్టడం. సో మనము పోస్ట్పోన్ చేస్తున్నాము, వీఆర్ పోస్ట్పోనింగ్ ద పనిష్మెంట్. సో దెర్ ఈజ్ ఆల్సో అ డిఫరెన్స్ బిట్వీన్ రిప్రైవ్ అండ్ రెస్పైట్. When we say reprieve, we are temporarily postponing, and respite is giving relief to the person, giving relief to the person. That relief may be on various conditions. We have some special conditions for special cases. రిస్పైట్ అనేది ఒక ప్రెసిడెంట్ యొక్క పవర్, జ్యుడిషియల్ పవర్. ఆ పవర్ యూజ్ చేసుకొని కొన్ని స్పెషల్ కేసెస్ లైక్ మెంటల్లీ అన్సౌండ్ పర్సన్ ఉన్న, లేదంటే పర్సన్ యొక్క ఆరోగ్యం బాగా లేకుండా, ఇఫ్ ద పర్సన్ ఈజ్ ఇల్ ఆర్ ఓల్డ్ ఏజ్ని మనం దృష్టిలో పెట్టుకుంటే, లేదంటే కొన్ని స్పెషల్ ప్రివిలేజెస్ ఇవ్వడం మహిళలకు, ప్రెగ్నెన్సీ కానీ, ఓల్డ్ పీపుల్ కానీ, హెల్త్ డిటోరైట్ అయ్యే కండిషన్స్ కానీ, అలాంటి కొన్ని స్పెషల్ కండిషన్స్ని మనం తీసుకొని రిస్పైట్ అనే పవర్ యూజ్ చేయొచ్చు. దానివల్ల ఏంటంటే ఒక క్రిమినల్కి ఆర్ ఒక కోర్ట్ ఇచ్చిన తర్వాత ఆ పర్టికులర్ పర్సన్కి కొంత రిలీఫ్ అనేది దొరుకుతుంది. సో రిస్పైట్ ఈజ్ ఆల్సో వేర్ ద పనిష్మెంట్ ఆర్ ద పర్సన్ వుడ్ get some relief from the punishment given by the courts. So here the conditions may be special, because due to those special conditions the president would issue the power or use the power of respite. So we have suspension, remit, commute. These sentences, again when we say these sentences where the president has the power, where the jurisdiction of the president, whatever the cases are within the jurisdiction of the president could use these powers. And also the president uses this power of pardon under Article 72 on the convictions of court martial also. Court martial, సైనిక న్యాయస్థానం ఇచ్చిన పనిష్మెంట్ని కూడా ప్రెసిడెంట్ ఈ పవర్స్ యూజ్ చేయొచ్చు. అదే మనము గవర్నర్తో కంపేర్ చేస్తే, గవర్నర్ డు నాట్ హ్యావ్ ద పవర్ ఆఫ్ పార్డన్ ఆర్ ఆల్ దీస్ థింగ్స్, కమ్యూటేషన్, రిమిషన్, వాట్ ఎవర్ రిగార్డింగ్ కోర్ట్ మార్షల్. కోర్ట్ మార్షల్ అనేది సైనిక చట్టం అనేది యూనియన్ లిస్ట్లో ఉంటుంది. ఖచ్చితంగా ప్రెసిడెంట్ అనేది యూనియన్ హెడ్ కాబట్టి ప్రెసిడెంట్ చేతిలో మాత్రమే డెత్ సెంటెన్స్ మరియు కోర్ట్ మార్షల్స్కి సంబంధించిన పనిష్మెంట్స్ మీద ఇలాంటి పవర్స్ యూజ్ చేయడం జరుగుతుంది. And one thing, as we all know that generally Article 74 says that there will be a council of ministers headed by the prime minister, and the council of ministers will aid and advise the president. So Article 73, 74, 75 ఇదంతా మనకి పార్లమెంటరీ సిస్టమ్ ఆఫ్ గవర్నమెంట్లో చాలా ఇంపార్టెంట్ ఆర్టికల్. సో ఇక్కడ ప్రెసిడెంట్ చేసిన నిర్ణయాలు ప్రెసిడెంట్ సొంత నిర్ణయాలు కావు. సో ఖచ్చితంగా కౌన్సిల్ ఆఫ్ మినిస్టర్స్ యొక్క అడ్వైస్తోనే ఇక్కడ ప్రెసిడెంట్ నిర్ణయం తీసుకోవడం జరుగుతుంది. దట్ ఈస్ ద రీజన్ వై ద యాక్షన్ ఆఫ్ ద ప్రెసిడెంట్ కెనాట్ బి క్వశ్చన్డ్ ఇన్ ఎనీ కోర్ట్, బికాస్ దోస్ యాక్షన్స్ ఆర్ నాట్ ద యాక్షన్స్ ఆఫ్ ప్రెసిడెంట్ himself or herself, but the actions are based on the advice of the council of ministers headed by the prime minister. So as we said, the president could seek advice from the Supreme Court under Article 143, not subject to the scrutiny of the court. These advices by the president are not subjected to the scrutiny, because as we said, the president would act on behalf of council of ministers. And this is also we've discussed appointment of Supreme Court, High Court judges. So on what basis they are different? So here we have a few powers regarding pardoning powers. We have no right to oral hearing. No person can directly meet the president or demand the president to let that person know about the judgment. So president would generally do not have a communication with the person who is guilty. So a fresh view can be taken. As we said, the Supreme Court already gives a punishment based on certain evidences, but a fresh look can be taken by the president on new evidences. He only acts on the advice of the Union Cabinet, that is Council of Ministers, and not bound to give any reasons to anyone, be it to the people, media or anyone. The president would generally do not give reasons for the actions taken or the for not taking any actions also. So he will generally afford relief. So we do not have any specific guidelines for the Supreme Court on the reason why the president should have given the pardoning powers. As we already said that the president action is subjected to partial judicial review if the decision of the president is arbitrary, that is, do not follow any procedure of the law, if the decision is unreasoning or unscientific, or it is malified to the constitution, then on such decisions of the president, the court would obviously have a power of judicial review. If it is politically motivated, or if the decision of the president is again has a political color or would affect a section of the society, then definitely the court would order for a judicial review on such decisions taken by the president. Here when say president decisions is not subjected to judicial review, but after many cases in the Supreme Court, the Supreme Court said that on basis of these reasons, like the arbitrariness of the decisions, or if it is malified, if it is irrational, then the court would have the power of judicial review. One more thing is, when a petitioner, that is a petitioner, files mercy to the president, and once the president rejects such petition, mercy petition, be it regarding the pardoning power, death sentence, or reducing the sentence, whatever be the reasons, if once the person submits the mercy petition and that petition is rejected by the president, again the person should not file for the pardon or for the mercy or to the president. So once it is rejected, then it is rejected. As we have discussed that Article 143 talks about advices to be taken by the president from the Supreme Court. So very simple but very authoritative, because judicial power is very important. Here president will exercise almost all the powers regarding judiciary. He right from appointment of the judges to pardoning power under Article 72. The president has enormous judicial powers, but subjected to many restrictions. As I said, the president would not take any decision on his own. The president would act on the advice of the Council of Ministers. Thank you for watching my video.